Right, so this is the lecture in LAWS12066 Land Law for topic 6, covering the alienability of proprietary interests and perpetuities. So I'll just share the slides without further ado. So where are we going in this topic? We need to think about the idea of future interests and how the law, property law, or land law relates, governs that. We need to see this idea of alienation and how the law responds to this notion of alienation and takes a position of preventing the idea of restrictions on the transfer of property. We then move to the significant idea of the rule against perpetuities, which is referred to today as the modern rule against perpetuities because it has an ancient origin, but we're very much focused on how it applies today. And in Queensland, that means understanding the common law situation, but also, very importantly, to appreciate the provisions in the Property Law Act under Part 14. And in that context, which I'll show you shortly, to be mindful of the reforms which are being proposed by the Property Law Review 2018 to Part 14 of the PLA. And important to remember that those reforms, of course, are proposals at this stage. They don't constitute the law, but in any area of thinking about policy, reform, considering this area, then that's important to see where the thinking is moving, and there are some significant suggestions there for rearranging the situation as governed by Part 14 of the PLA, and just have an overall understanding of the underlying principles that are governing perpetuities in the modern period, understanding it's come out of an historic, fairly ancient context, actually, in terms of this idea of a response to attempts by freeholders and fee simple interest owners to tie up land. How does that work today in modern society, in Queensland and more generally across Australia? So some of the key terms that we're looking at here: perpetuity period, idea of remoteness of vesting. Often the rule against perpetuities can also be referred to as the rule against remoteness of vesting, because that's essentially what it involves. The idea of remainders and the idea of reversionary interests, potentially. So we start with looking at the judicial doctrines on restraint against alienation, and this is covered in your casebook, really starting on page 644 and going through to 659. And there's a significant case extract of the recent decision of the New South Wales Court of Appeal, 2011, of Bondi Beach Astra Retirement Village in Gora. You can see there in the slides that basically I'm indicating for you to have a look at the Bondi Beach case. When you read this case, you can maybe think about the vistas of Bondi Beach. if you haven't seen that famous beach in the Sydney area. But this involves a retirement village in that area. And then the article by Grattan, and the article by Grattan is, Scott Grattan, is referred to significantly, and this short extract taken from his article at pages 657 to 659. And then also the application of, if you like, the approach in Gora in Queensland, which is reflected through the decision of Re-Permanent Trustee Nominees Canberra Limited, which is a 1989 decision. Now clearly predates the Gora decision, so it's not applying Gora, but there's consistency with the approach that was adopted by Justice Campbell in Gora in relation to earlier case law. And I'm not going to go right through the Gora case. You can have a look at that and have a review of it. But the point that I want to bring out from Gora is that, and you can see, essentially what's going on in Gora was we had a scenario with a retirement village. We had those residents of advanced years in the retirement village. The idea of them being able to acquire a fee simple interest, and then there were options in regard to agreements that they had entered into, which somehow seemed to limit the alienation of property. And it was in that context that this dispute arose in terms of, well, was that contract valid? The agreement, which included an option, valid because it had the effect of restraining alienation and so on. What we found is that Justice Campbell, the judgment, which has been extracted for you, went through and reviewed that situation. He significantly looked at the early decision of Hall and Bust, a High Court decision involving this idea of restraints against alienation, and have a look at that, which is discussed in the judgment at 644 to 6545 of your casebook. But essentially what comes out of the Gora case is, in that context of the factual matrix, there's this tension between, on the one hand, the law's general position that it will not accept unlimited restraints on alienation, and that's where we come to the rule against perpetuity shortly. That is, we've emphasised this in the Term 1 course, and it's been a bit of a thread coming through land law as well, that land has a purpose and a utility. Okay, its purpose and its utility is for use, and that is, it can be used for purposes of habitation, for living, accommodation. It can be used for industrial, commercial, agricultural purposes, but it doesn't serve those purposes if it just is tied up and nothing can be done with it, or the ownership can't be passed on because the historical owner has put limits and ties, and that's not permitted, and there's restraints on that alienation, that is, the capacity for it to be freely transferred. Right? In Gora, we find Campbell identifying a tension between that public purpose of not accepting restraints on alienation with the interests found in private agreements, which can have the effect of restraining alienation. And we see, for example, that Campbell says, for example, at the bottom of page 653 in the extract from his judgment, much of the case law relating to the free alienability of freehold estates in fee simple has arisen concerning limitations on alienability that are imposed by the terms of the grant itself. Many of those cases are influenced by the concept of the restraint being repugnant to the grant, which in turn was influenced by medieval conveyancing principles about the impossibility of limiting an estate after a fee simple. The outcomes of those cases do not necessarily translate into the different universe of discourse applicable to contractual restraints on alienation, which is dependent solely on public policy. So Campbell is saying we've got this historical origin of this idea of not accepting restraints on alienation, but we're operating in a very different climate today, where much transacting, particularly with regard to interests in land, is done via contract. And whilst there's this connection between contract and property law, as we saw in the Term 1 unit, and as we'll see further, for example, when we look at the topic on leases, they are distinct. And the interests in property are recognised by property or land law, and then you've got contract being mechanisms for transferring interests in property, and they're working together, but we can't deny either, if we can put it like that. And individuals, parties can enter into contracts freely according to the principles of contract law, bind themselves in various ways. This can have a proprietary impact. How far do we go in allowing that to countermand what property law considers to be significant? And further in Campbell's judgment, a bit further down, he says in the next paragraph towards the end, there is a public interest in the owner of property being free to alienate it. But that does not mean there is a public interest in the owner of property being free to alienate the property twice to different people through inconsistent dispositions. Because the law concerning permissible restraints on alienation imposed by a contract is based on public policy, it should operate by reference to the substance of an agreement and not to its form. So Campbell is sort of trying to articulate how we get an accommodation here. And in the end, the court found that the contracts that had been freely entered into by these parties should continue to adhere. But there is this underlying tension, and Gora brings this out very nicely. The comments that are made by Grattan and extracted on page 657 to 658 are interesting, because we need to remember the actual context within which this was happening. Retirement village. Retirement village has older people that need to be accommodated, and yet they're making choices with regard to that accommodation because they're in that situation of life. Grattan says, in identifying the importance of society of providing accommodation for the aged, the court in Gora gave expression to a conception of property as a means of a proper social ordering. So here's the idea of the underlying social purpose within property law or land law. We touched on this and worked with this to a degree in Term 1 unit. Here it is resonating again in land law, and we'll see it again resonating when we come to a topic on social housing to some in another context, if you like. The values that underpin the way in which property rights are allocated are not to the satisfaction of individual preferences and the efficient use of resources. He then concludes, in certain contexts, the rules that promote the free alienability of property should be able to be displaced by private agreement, especially where private agreement serves the public and not merely private interest. So there's a tension between property law notions and contract, and there's a tension between private interest and public interest. How do we get that tension right? How do we get the balance right at the end of the day? Ultimately, and arguably, it's an accommodation. It's an interesting word to use in the context of land law, isn't it? But basically what it means is that I want to suggest to you that there's not a hard and fast, but it's an accommodated position based on the circumstances, based on an investigation of the situation, but mindful of the underlying purpose and values. That's always important. Very important in this area of the law to keep reminding ourselves of that. I think sometimes in land law, things start to appear a bit doctrinal and a bit sort of, how can I put it, a bit sort of mechanistic, in that we've got an array of rules to be applied and worked in different situations. We must never forget to take a step back and to consider the underlying purpose and rationale for the framework of law that's evolved and continues to evolve, as we're going to see just shortly when we move to the rule against perpetuities and the reforms that have been proposed by the Property Law Review. So, we then move on to the idea of perpetuities, And as I said earlier, that this is an area that's governed by both common law rules and the Property Law Act in Queensland. As we've just been seeing, the common law favoured free alienation of property. And this goes all the way back, folks, to the 13th century in England, okay? And the Statute of Quia Emptores, 1290. And again, we saw that in the Term 1 course, touched on the doctrine of Quia Emptores, particularly in the context of the doctrine of tenure, doctrine of the states. So it's got this very long, ancient pedigree, but we are concerned to see how does this idea of alienation and restraints on alienation work today in modern period and in Queensland in the 21st century. So we then see that we have a rule developed common law which is still applicable today, and it's important to remember that, in that a clause in a will or other instrument preventing the alienation of land is void as contrary to public policy. Okay, so that's the starting position, because where this comes out of is that historically freehold owners did try, and before the law advanced itself, to tie up the alienation of property through almost like a dead hand control from the grave. It could never be ultimately transferred. And the law just said at the end of the day, this is obnoxious and repugnant. Right, so you'll find the discussion of the rule against perpetuity in your casebook, starting on page 660 and going through to 693. Now, what I want to emphasise with regard to that discussion, as I have previously, is we're focusing on the position in Queensland. I know that we've got students all over various jurisdictions, which is excellent, but we are teaching to the Queen, and we're studying this unit to the Queensland legal framework, as we know. So as you work yourself through this material on rule against perpetuities, you need to focus on the discussion in the notes that emphasises the Queensland position, the Queensland law, Queensland provisions of the PLA, and you're looking for that in the discussion in the casebook, okay? Not worrying about what's going on in other jurisdictions, because again, as we've seen in other areas, the position is not identical across the jurisdictions. We have specific legislation introduced, many jurisdictions, as you can see there from the casebook, do, but how those provisions work is not exactly the same in the various jurisdictions. That's something that just need to be mindful of. So you can see there on the slides that I've just referred to the article by Allen, Rule Against Perpetuities Restated, and there's discussion of that in your casebook 661 over to 663. Really 663, and Allen, that article was written back in the 1960s, University of Western Australia Law Review. It is a way of explaining the rationale of the rule against perpetuities, its historical basis. Allen also takes issue with its continuing relevance in the modern period. And you can see, for example, I take an extract from Allen in the article by Allen from the casebook, in looking at the policy question that's raised, and looking at this idea that this freedom to dispose of assets is about the proportion of assets, the period of control, and the capriciousness of the purpose in relation to the control. Allen points out that the rule against perpetuities is directed towards the second of these, that is the period of control. It is only in the need to limit the period of testamentary control for social reasons that the rule today is required. That's Alan's position. Okay. Now, in light of the review of the PLA and Part 14, I'll come to that shortly under the property law review, the justification and the continuing justification of the rule against perpetuities today needs to be appreciated in that context, so that to have that review process and the discussion there very helpful for possible policy type areas that might be considered going forward. So really encourage you to have a look at that, those relevant pages of the PLA review. Don't forget, folks, I've mentioned before, PLA review is a substantial document, substantial, right? And I am not requiring you in any stretch of the imagination to work your way through all of that. But I provide you with the whole document. It's there in one place. That's convenient. And I'm directing you to the areas where the reforms are being suggested, which is useful in terms of the particular topics that we're considering. And this is one of those, Part 14 of the PLA with regard to rule against perpetuities. So, just moving along. So you can see there is I've given you a bit more from that in terms of the Alan article, and that's particularly, replicating what I've said in the slides, and I've just referred to that, so you can have a look at that. Right, so now we have what's referred to as these absurd scenarios, and the absurd scenarios really are about situations that arose as a result of the application of the common law, strict application of the common law rule against perpetuities. These are referred to as the fertile octogenarian cases. Fertile octogenarians, beware. Precocious toddlers, as ever. Unborn widowers, and the magic gravel pits. Who would have ever thought that gravel pits had magic in them? But there you go. The other point here is that you can see these discussed in your casebook, page 671, over to about 675. The other thing which is helpful in the casebook, I think, is that this particular chapter is, as it's moving through the various themes and issues, it's providing you with examples. You can see it's quite a sequencing of examples. So they run from the first example, pops up on page 667, and those examples continue to travel through the chapter. Right up through until, I think it's example 35. So 35 examples. So practical illustrations to guide you through the process. Now, not all of that's relevant for us. So, for example, pages 690 to 691 on the New South Wales legislation, not relevant for us. And again, we're not concerned about the situation in other jurisdictions. But to the extent that the examples highlight and help to explain what's going on in Queensland, they're important. And then at the end of the chapter, very helpfully, there is a scenario there, which is actually example 37. And I picked this up in the tutorial question. So that's, this area is a very good area to understand by application through some practical illustration. Okay. So basically, these scenarios arose through the strict application of the common law rule, and you can just have a look at how they occurred. And you've got the examples there on page 668, showing how this was possible to arise. So have a look at those. But there's been a response to that by the law. We have the the rule against perpetuities that's stated in the Air Jamaica case, which is an English decision. And we also now have the Nemesis case, which is actually very helpful, and I've given you an extract of that on the Moodle website, because that's actually a discussion of the rule against perpetuities in the context of the Queensland PLA. Okay. Right, so what we find is that this statement from the Air Jamaica case just spells out for us the modern rule against perpetuities prior to legislative intervention. So you can see, I document this for you in the notes. The court in the Air Jamaica case specifies that no interest is good unless it must vest, if it vests at all within a period of life in being, the date of the gift plus 21 years. A gift is defeated if, by any possibility, however remote, it may vest outside the perpetuity period. It is not saved by the fact that, in the event, it vests inside the perpetuity period. So what we find, and this is just before we get to that, so we've got this, as you can see on the slide, so we've got a confirmation in Nemesis that's also looking at the situation in regard to Queensland, just again contextualising for us that the rule against perpetuities, it's not a rule of construction, but it's a peremptory command of law in regard to what is possible. And again, quoted in the notes, the rule against perpetuities performs a useful social function in limiting the power of members of generations past from tying up property in such a form as to prevent it being freely disposed of in the present or in the future. So there's the rationale lying in the restraint on alienation. Okay. Now, when we look at those elements that I've just referred to before from the Air Jamaica case, we find that these are reflected, as you can see there in the next slide. Okay. Vesting of interest and presumptions, perpetuity period under common law, 21 years, lives in being, certainty of vesting, must vest if at all. So we'll come to the Queensland provisions shortly and the impact that they have. That statement from the Air Jamaica case, that a gift is defeated if by any possibility, however remote, it may vest outside the perpetuity period, that was what led to those common law absurd scenarios. If, however remote, it was the fertile octogenarian, the precocious toddler, the unborn widower, the magic gravel pits, these were situations that arose that led to that possibility, however remote it was, that the property may vest outside the perpetuity period, which was a life in being, the date of the gift plus 21 years. So that's where those absurd common law scenarios arose from. We now need to consider the impact of the Property Law Act in Part 14. So just before I'm just going to screen share the legislation for you. So here we have Part 14, Property Law Act. This is the current legislation from the Queensland legislation website. You can see there, just running through, that section 206 through to 222. And you can just run through the section Power to specify the perpetuity period, 209, that's important. The definitions under section 206. We'll come back to 206A and B with regard to dispositions in a will, and also when a person is to be treated as a member of a class, and class closing rules. We'll touch on those before we finish. Section 210, the wait and see rule. This was partly to overcome the absurd scenarios that arose from the strict application of the common law. Section 212, presumptions and evidence as to future parenthood, and the reduction of age and exclusion of class members to avoid remoteness of vesting. Section 213. 214, the unborn husband or wife situation. And importantly, section 217 with regard to restrictions on the rule, on the perpetuity rule. And options is also specifically dealt with under the current PLA. So I'm just going to stop screen sharing that, come back to the slides. Right, so we've got sections 210 and 209 dealing with the perpetuity period of 80 years in Queensland. Right? So that's under legislation. We've got sections 210, 212 and 214, which deal with certainty of vesting and, as we saw, the wait and see rule. And then we've got sections 213 and 206B dealing with class closing rules, which changes the all or nothing position at common law. Again, this is where a gift, testamentary gift, is being given to a class of individuals, and the issues about whether it will vest to one member of the class or not, and how the common law took that in terms of the mere possibility of it outside, the vesting occurring outside the perpetuity period, then that would have led to the gift failing. The legislative intervention here is again trying to make the gift not fail, and that's the effect of much of the legislative intervention, is to make the rule operate in a more practical and effective way in the modern period. But secondly, to gifts that are made in a testamentary context, to, as far as possible, to try and make them be able to be successful according to the intention of the maker, that is the testator or testatrix, to allow the gifts to vest. And then that is consistent also with the idea, the underlying rationale of the no restraint on free alienability of property. All right, so just before we come to the effect of common law, I want to share with you now is right, so here we have the Property Law Review Final Report 2018, and we've got discussion of Part 14, Perpetuities and Accumulations. So that's going from page 888 see there's a fairly substantial discussion of this in the report. I won't go through all that, but it's certainly starting at page 888, which you can have a look at. But I just want to point out something important. So you can have a look at the various aspects of that. Right, so it also, this report, gives an excellent overview of the history of the rule and how it works, how it has worked in Queensland, situation with regard to provisions under the PLA. It's also reference to what's happening in other jurisdictions, which is really good. Then we come to the recommendation 169 dealing with the perpetuity period. Now you can see there that what's being proposed is the rule against perpetuity should be replaced with a single perpetuity period of up to 125 years for dispositions of an interest in property that take effect after the commencement of the new provisions. Existing dispositions of property should remain subject to the perpetuity period in place at the time the disposition took effect, subject to an ability to opt in to the longer perpetuity period in specified circumstances. This again is a response to the variability of the rule's application. Under the current PLA, it's 80 years. This is being proposed to extend to 125 years, again, to further overcome any concerns about remoteness of vesting. The purpose here to enable the gift to vest at the end of the day. So those reforms, have a look at those. Again, emphasise that in areas of policy and discussion of policy or questions that might come up with regard to policy, this discussion here is important to think about in terms of proposals. Remember that, this is proposals. And what are your thoughts about that? How do you feel about these proposals that are being made? Okay, so have a look at those provisions of reform. Come back to the slides. Right, so we then move on and look at the effect of infringing the rule against perpetuities. And we find that we've got the common law position that if a particular contingency in an instrument is rendered void because it infringes the rule, any prior interest takes effect just as it would have if the void contingency had not been inserted in the gift. Okay, so as an attempt to try and excise the void contingency to allow the gift to operate, but now we've got section 215 of PLA. It's going to show you that again. So there's 215 dependent dispositions. A disposition shall not be treated as void for remoteness merely because the interest disposed of is ulterior to and dependent upon an interest under a disposition which is so void, and the vesting of an interest shall not be prevented from being accelerated on the failure of a prior interest merely because the failure arises because of remoteness. So again, there's an attempt there by the legislature to find ways to allow gifts to ultimately vest and then not breach the rule against perpetuity, so the modern rule as understood in light of the legislative provisions. Also in relation to the effect of infringing the rule is we mindful of the possibilities of it reverting, of the gift reverting, the right of entry by the original provider, options and contracts. So we saw that in the Gora case, how options and contracts can can restrict alienation, and how do we understand the balance to be struck between the public purpose of no restraint on alienation and the effect of private agreements having that consequence. And in this context, have a look at sections 217, 219 and 218 of the PLA with regard to the effect of those infringements. So just before we get to that, just also go back and just also emphasise the class closing rules with regard to class gifts. So understand the common law position. I might have just, let's go back and look at that again. Yeah, so under section 213 and 206B, class closing rules change the all or nothing position of common law, as I indicated previously. So just be aware of that. Have a look at the notes and the discussion in your casebook dealing with the class closing rules. Which is on page 679. And following. And you can see there, for example, in the notes, the very early English decision of Andrews and Partington, the rule allows the closure of a class of people at the date when the first member of the class becomes entitled to take, irrespective of whether the class is capable of further growth. And so and it's in that context that we need to think about the implications of the PLA provisions, in particular 206B, and how that works, and go back and have a look at 206B and its impact in this area in terms of the class closing position. So what we arrive at is there's a process here to understand how the rule operates. There's a need to think about the common law as well as the critical provisions of the PLA under Part 14. Be mindful of the reforms that are being proposed with regard to Part 14 and the reasons for that. Okay, but in thinking about working your way through a perpetuities problem, then I've given you a step-by-step process there, and so you need to start by determining the date of creation of the interest. You then need to determine who is the life in being. If appropriate, apply the old rule against perpetuities, because maybe the legislation isn't applicable. You have to ask yourself, have we got a class gift here, or is it just a gift to a single entity, a single person? Class gift is a gift to multiple persons. If it is a class gift, then we apply the common law rules, and then we determine if the statutory reforms are applicable and how they work. So we go thinking about the common law, then coming to the effect of the legislation. If this isn't a class gift, then we apply the modern rule against perpetuities. We determine if the statutory reforms are applicable, and then if any of the interests have infringed the modern rule against perpetuities, then we deal with the outcome and the consequences of that. So there we have the rule against perpetuities. Work through some of those examples, or have a look at the worked examples, better way to put it, in the casebook, and then we'll have a go at that larger one in the tutorial class. So this topic has been about the thinking about restraints on alienation of property, looking at how common law and equity has sought to prevent or what its role has been, if you like, in the prevention of the free alienation, and not accepting the idea that you can tie up property forever, considering the rule against perpetuities under the common law and the critical provisions of the PLA, being mindful today of also the implications of the review, PLA review, which is proposing reforms to the PLA, but they are reform proposals, they don't constitute the current law, and then understanding basically the rationale behind perpetuities and how it works in the modern period. So there we are, folks. That's topic 6 on alienation of property and rule against perpetuities. Bye for now.